Suppose too early for the press. I've always shown the oath, this government.
Thank you. Dr. Walters, just finally with regards to your exhibits AAA11 to AAA13, the foreign peaks that you noted in those samples. Colonel Otto's testimony and comment when she was confronted with your opinions on the EPGs of AAA11 to 13 was, yes, I see what you are referring to, but the GMAP did not pick it up. So yes, it's possible that it could have been a stutter, a shoulder stutter, and a real, for an artifact, but I'm not going to testify or call on it because it's not labeled. It is dangerous to do so. Do you remember that evidence in that regard?
My Lord, I recall that she was asked about it, but her exact response I cannot not recall. But in broad terms, yes, I recall that. But there is an issue that was not brought to the attention of the court there, and that is the issue of that the analyst can also intervene at that point, the GeneMapper analyst, and enter a code to say peak labeling possible. So I cannot recall that that was addressed, my Lord, and if it was, then it is on the record. But yes, I agree with the gist of what Colonel Otto said, that it could be an artifact, an allele, etc.
And if I understand the excerpt that you handed in from John Butler's work, the copy is under exhibit EE6. Even he advises that one has to be very careful to make sure what exactly it is that you are noting before you call it, so to speak.
My Lord, indeed, in particularly in mixtures, it is challenging to interpret, and one should make sure as you can be.
And if I understand your evidence correctly with regards to the specific foreign peaks, you are not saying that you read the full profile of an unidentified person in those samples.
My Lord, indeed, what I testified to yesterday, what I called it specifically was a foreign peak, and it could be that it is the only peak of a potential. So one of the options is it's the highest peak of a profile that is present there. Neither myself nor the FSL could say whether that is the case or not. So in forensic science, there are three findings one can make: an inclusion, an exclusion, and an inconclusive. And in this case, the inconclusive statement applies, which is an absolute neutral statement. Both of us are just saying that there is that foreign peak.
So then, Dr. August, my question is, if this is a neutral statement you make, why bring it up?
My Lord, because that is how the scientific process works. One has to report the results and the full result of when I see the when I read through the affidavits handed into court, which are sworn affidavits by Lieutenant Colonel Otto, it again struck me that there were aspects in the electropherograms and in the data that was not mentioned in the report. So that is why I brought it to the attention of the court, because, my Lord, it speaks to a critical aspect of scientific validity, and that is the uncertainty of measurement. So I understand that the court wants certainty, but I also understand that every scientific measurement has uncertainty built into it. My Lord, this is not what I am saying, this is what the ISO guide is saying. Previously I was asked by the state whether the SOPs of the FSL are aligned to the ISO guide, and I can today categorically state that they are not aligned fully to the ISO guide. Because of this uncertainty of measurement aspect, I electronically searched so that I don't make or attempted not to make a mistake in missing something that I could read over. I could not find the word uncertainty of measurement or the words uncertainty of measurement, or that the SOP speaks to what is the error rate of their test. And so ISO 17025 makes it very clear that uncertainty of measurement not only can be addressed, but should be addressed. And my Lord, I won't read the whole paragraph, I will just refer to it so that it is on the record. So in the ISO guide paragraph 5.4.6.2, I am just reading into the record that testing laboratories shall have and shall apply procedures for estimating uncertainty of measurement. And it goes on to say, there's one sentence in between, my Lord, and to avoid confusion later, perhaps I should read in then the full paragraph. In certain cases, and I quote again, the nature of the test method may preclude rigorous metrologically and statistical valid calculation of uncertainty measurements. In these cases, the laboratory shall at least attempt to identify the components of uncertainty and make a reasonable estimation, and shall ensure that the form of reporting of the result does not give the wrong impression of the uncertainty. And then on the next page, the very last paragraph that I will read in terms of uncertainty of measurement is 5.4.6.3. When estimating the uncertainty of measurement, all uncertainty components which are of importance must be given in the given situation shall be taken into account. I'm not completing that sentence, my Lord, but what is very important is that note 1 also mentions, my Lord, note 1, the very last aspect, or the very, it is one line, it says sources contributing to the uncertainty of measurement. It lists a long list of things. The very last thing it lists is the operator, because we understand in science that even as scientists we can also make a mistake, as in this case where the interpretation had an alternative explanation and was not stated. That, my Lord, is the reason why I mentioned it in my report, because I felt clearly from the ISO guide that the full result was not reported.
Even though the full result is uncertain.
Yes, my Lord.
Now, Dr. Walker's moving on to Exhibit 889 that took over from, excuse me, from yesterday. My initial question to you regarding the samples in the same case following each other on isolation work list is that the literature that I could find on the internet notes that this as something that does sometimes happen, so it's not an unusual or unheard of occurrence. And you wanted to, if I remember correctly, you wanted to find some literature or some document to answer this question.
My Lord, thank you for the opportunity to go back to this. I want to state that there are more than this that I need to clarify from yesterday, but I will start with this. What I wanted to do yesterday, and still would like to do today,
Lord, I'm just...
my Lord,
I also want to ask something. This is the second time that you referred to broad internet-based knowledge as being good to her. I would much prefer it if we at least know what it is.
Yes, but we can't have these long answers. Let's try to explain shortly what you're saying, please, Dr. Arthurs.
thank you, my Lord. So taking these two, yesterday my Lordship gave me time to look for these two samples that follow each other on a work list. And I just need to get to the work list exhibit number so that I can refer the court to that. Was it triple A9? My Lord, there is a work list where these samples, from the case followed each other on a work list. The SOP said that could not be done. It is in the SOP, I believe, of contamination, so why samples should not be following each other on a work list. My Lord, I'm coming to the exact...
I don't want to interrupt you because council says I must allow you to answer your own words. But you give very long answers to a very simple answer. I merely put it to you, to a very simple question. I merely put it to you. I did a little bit of research on the internet, random reading about DNA. I came across the comment that the concept of same case samples following each other on isolation work list is not unheard of or it is not unusual or unheard of. Are you aware of this or not? That is all that I'm asking you. We will get to your work list and your AAA9.
My Lord, the council is asking me about specific aspects she found on the internet. The prevailing texts in the forensic science field says every possible measure should be taken to avoid contamination. A part of that is also placing samples of the same case not on the same list. So I'm not disputing that there may be one or two internet reports about that it was done in a case or could be done in a case. I'm talking about the body of knowledge out there and how we understood it as
Okay. You made your point.
in the
Next
broad
question.
context.
Now, you keep referring when we specifically look at AAA9, when you made a summary of all these work lists or batches where these samples follow each other. You keep referring to the empty lanes on the batch list provided by the laboratory. What exactly are you trying to convey to the court?
My Lord,
Referring to the empty lanes.
My Lord, I'm trying to convey to the court merely that I do not have information about those lanes, so therefore cannot make a statement either way. So I'm trying to be as neutral as possible about information that I do not have.
Colonel Otto testified that the reason why there are empty lanes indicated in the batch lists and on the work lists and everywhere in the detail in the paper trail that was supplied by you is because the laboratory went and they removed all the information from other cases from the paper trail so as to not to compromise the information of other cases and very relevant, very real thing in criminal law, it's not relevant to this case.
My Lord, I absolutely agree that I do not need any information that's not relevant to this case.
Okay.
So then do you have any evidence to the contrary to say that those lanes are deliberately left empty to create the wrong impression of the court?
My Lord, if I may just say no, that is not the impression I want to bring the court under. However, my role in this audit process was I do trust, but I need to verify. So that is the only thing. There's nothing malicious meant by it. It's supposed to be a neutral statement. I'm just indicating to the court I could not verify what were in those lanes. And in the absence
I
of...
hope your audit processes are more stringent than KPMG. That's not, you don't take that seriously.
I'm not answering it, my Lord.
Good.
I took it as a
Now, so in actual fact then, Dr. Ortiz, you cannot dispute Colonel Ortiz' evidence that those lines are empty because it refers to the information contained in those lines related to other cases.
My Lord, with the information that was made available to me, I cannot dispute that statement because I literally don't have the information.
So then paragraphs 2.2 and 2.3, except for in 2.2, the middle three, the action says corner, shower for, and head on acts, those don't actually follow each other. There are samples of other cases in between.
Correct. In lines 6 and 7, there are other samples in between.
names, the work lists, these are randomly created by the Star Lab program.
My Lord, I don't think randomly, because I think the Star Lab program is an algorithm, computer program that was written, and it should have been written in such a way so that it complies to the ISO guidance and to the SOP. So I would assume that if the Star Lab system assigns it, it will assign it to every second lane, because that is what is required in the SOP.
And in a case such as this, one before the court, when you yourself testified, you've never seen a case with so many samples, and they must all be processed within a reasonable time. Would that not cause that at times samples would follow each other?
My Lord, as much as I would like to agree, I cannot, because one cannot sacrifice quality for the sake of expediency. I understand the logistical challenges that the FSL faced in this case.
The
My Lord.
amount of samples involved, the logistical challenges must have been enormous.
I agree, my Lord. We received 4 affidavits, in fact. Usually we receive 1 in a case.
That's understandable in this case.
Yes. And the last one was dated in December, so we received from Lieutenant Colonel Otto affidavits throughout the year on several dates, from January, I believe, to December of that year, of 2015.
Dr. Orcus, if you quote on Exhibit AAA9, paragraph 1, subparagraph A, Roman 1, you refer to SOP Bio 0067P, page 7 of 9, paragraph 5.5.2, SOP bundle page 259. And then you give the SOP name contamination prevention and detection. You, in actual fact, and you indicate that in your quotation, you don't quote the whole SOP, is that correct?
That is correct, my Lord, because I do not quote the entire SOP, because the SOP at that point was already handed into court. There's a SOP bundle, my Lord, and may I please request that somebody just hand me that SOP bundle. Black file on top, thank you. My Lord, and I will just ask for time to just page to that
That is
page 259.
of 413.
Thank you, my Lord, I have the page.
If one reads the whole of the SOP document, you'll be getting a copy. It refers correctly to DNA isolation. To the SOPs applicable to the DNA isolation area.
My Lord, the version I have in front of me is entitled Contamination Prevention and Detection.
I'm speaking about the specific SOP in the middle of the page. I made this copy from Exhibit AAA that is handed in.
253.
Page 259, page 7 of 9, paragraph 5.5.2.
Yes, my Lord, the title I quoted was the title of the SOP. The title of the paragraph is called DNA Isolation Area, and then there's yellow in brackets behind it.
Now, the first bullet of that SOP states, perform isolations of evidence samples, prime index, at a separate time from the extraction of reference samples, reference index.
That's correct, my Lord, that's what the SOP states.
Now, if you have regard to your summary of the isolation work lists, it is clearly indicated that paragraph 2.1 are reference samples, reference samples, and then from 2.2 onwards, it is prime index samples. Is that correct?
Yes, my lord, that's what I've indicated on the on AAA9.
So all the samples that, according to you, incorrectly follow each other on the same work list are indeed samples from the same exhibits, more or less, if you look at the grouping thereof. Especially from paragraph 2.5 onwards.
My lord, yes, in 2.2, those are the axe, the corner of the shower floor and the head of the axe, so it's both about the axe. And then the bottom of the handle of the axe, the next one is about 3 separate pieces of evidence, so cigarette butts. 2.4 is about different parts of the handle, and then there's short stains on the next batch, but several distinct, shall I say, pieces of evidence that was handed in. So each was marked stain 3, stain 4, stain 5.
Which is all from the socks,
They're all from the socks, correct?
similar to the rest of the samples.
To
So
the-
the laboratory did not mix up the reference samples with the crime index samples.
My lord, that's my recollection as well.
And if the laboratory interprets this to say that, the SOP to say that, listen, we've received so many crime scene samples, that it's all crime scene samples, one crime scene, all from victims of the crime. There are no suspect samples that we received, and there are no reference samples. If they interpret that as not in contravention of the SOP, would that satisfy your reading of that SOP?
My lord,
In order to testify, he's putting out a position to her. I don't know, there wasn't testimony of that is how she interpreted it.
No, I never said them or to testify this. I never said.
That's not what he said. Please carry on.
No,
What is your point?
my point is that she's putting to her a proposition of how the FSL interpreted it. Dr. Orton didn't testify that is the way she interpreted it.
No, I never said firstly that the
She
audit
conceded that it was implied, sorry.
Thank you. Please carry on. Please carry on.
If, as I put it to you, Dr. Orton, if the laboratory were to interpret the SOP as such, to say that as long as we don't put reference or suspect samples together with victim or crime scene samples, the possibility of contamination is remote enough that we can continue.
my lord,
Would that satisfy your reading of that SOP?
My lord, I absolutely disagree with that. The reason I disagree is because the laboratory goes at other places to great pains to indicate when things can and cannot be done together. The third bullet is very clear to me. Samples of the same case, the same laboratory number, should not follow each other on work lists, but should be separated with other samples of other cases, in brackets, laboratory sample. It even goes so far as to say in the previous one, should duplicate isolation of a sample must be performed, it must be done at a different time and so. But it's bullet 3 that the state is taking an issue with, and it cannot be more clear to me that to prevent contamination, the FSL's own standard states that the samples cannot follow each other on a work list.
So your evidence is even though they face with logistical problems in a matter such as this one, they must stick to the formulae of the SOPs. They're not allowed to
Pick up
implement.
contamination.
My lord, I'm now being asked 2 questions. Can I answer?
The court
Uh,
will
Sorry
take
to
place.
interrupt you, but can you pick up contamination?
My lord, I wanted to show that possibility in the samples of yesterday, to make an example of that. So that will take a while to take the court through that. So
Let's get back to
so-
Mr. Callaway.
can I just ask that the question be repeated, my lord?
Certainly, can I please? Sorry, Mr. Callaway. Sorry.
Oh, yeah. So your evidence is, Dr. Altus, even though the laboratory was faced with logistical problems in this particular matter, that they're not allowed to interpret the SOP as they see that it will not it will not cause contamination, the risk of contamination to be too high, and then follow that. You want them to follow the SOP literally, formulatively.
My Lord, if I can just make a quick note to myself. So I want to be as clear as possible and as short as possible in my answer. Yes, the lab cannot, for logistical reasons or any other reason, sacrifice the quality that is stated in their SOP as is mandated by the ISO guide. That's the first point I want to make. The second point I want to make is, before an experiment is conducted, it stands to reason that one does not know the answer. My Lord, so to take swabs or samples from, let's say, the shorts, and to then think, well, it's all from the same shorts, it's probably going to not be able to contaminate. How does the lab know that before they've done the experiment? So, therefore, I'm not saying there was. In a hypothetical example, there could have been another profile, unexpected profile on the shorts. And how will the lab then know whether it will, that they've done everything to ensure that that sample is scientifically valid? So one cannot sacrifice, as I said before, for the sake of expediency or logistics, as much as we all, as citizens of this country, would love to perhaps say this case or other cases with a lot of samples should be handled different. We cannot, my Lord, because the ISO guide and the standards that are set out by the FSL prohibits them to do that. And that is in line with the absolute standard practice in the field.
And then, so in instances such as this, where the STAR Lab program creates a batch list, as per the program it was written to run with, you now are suggesting that the analyst must go and change the order, because the STAR Lab program has now placed these samples on one work list? Because that, I'm sure, must also be in contravention with some other SOP.
My Lord, I understand that the STAR Lab system is a computer program. That algorithm is written by people, and it must have been written in a way to comply with the SOPs, because how else could that, the reverse of that argument makes no sense to me in a forensic laboratory. So I would have assumed that the STAR Lab program is programmed in such a way that it puts the samples in alternative lanes so that it complies with the SOP. And not complying to the SOP, my Lord, is not a mere technicality. This can have real significant impact. And so the SOP was then contravened, the ISO guide was contravened, all of these things. I agree with Lieutenant Colonel Otto, must be followed. She testified to that. So how it came about that the STAR Lab system assigned the same case in different lanes, my Lord, I was not there. I can only audit it from the...
All you can say is it can have a significant impact.
It can have a significant
Not that it did
impact.
have a significant.
My Lord, I will show one example to the Lord, to my Lordship to explain what I mean. So whether the STAR Lab system was in contravention of the SOP or how this happened, that I cannot testify to. I can only testify to what I saw on the work lists.
Then, Dr. August, you also pointed out to the court another SOP that, in your view, was not complied with by the laboratory, is in the tests done by Warrant Officer Nyao, in the presumptive tests for blood in the preparation of the sample. Now, you are aware of the fact that her tests with the hemasticks are merely presumptive tests.
My Lord, if I can just have a moment to get to that SOP.
Yes, certainly. Yes, Dr. Olkers, please sit here.
My Lord, thank you. I appreciate it. It's not that I'm sitting because I'm tired. I have an ankle
Yes, no.
injury, and sometimes it just alleviates it
No,
to,
you
to
have
just stand up.
absolute right to sit.
So
You can't look.
I appreciate the indulgence and the concern of the court, my Lord. My Lord, I just have to go to my own report to find the clause that refers to the specific SOP, unless the state can refer me to it.
I thought you didn't make a note of it, Dr. Olkers.
It's the SOP 40.
Just adjourn for 1 minute, please.
For assisting, we found the hemasticks SOP, as you pointed out, page 221 and 222 of 413, SOP bio 0043P, page 144, with the heading hemasticks.
That's correct, my Lord.
Now, the question that I asked you, Doctor, is you are aware of the fact that the hemasticks tests are only presumptive tests.
My Lord, I am aware of the fact that hemasticks is only a presumptive test. However, it is a very important part of analysis to identify body fluids that goes into the process of the laboratory. So I agree it's a presumptive test, and I beg the indulgence of the court to just allow me to add the following, because it is a critical part of it on page 368. It also talks about sample preparations and cuttings, and then it talks about how important is this hemasticks. And it says prior to, my apologies, paragraph 9.4.8 on the SOP bundle, page 368. It says prior to any body fluid swab to be submitted, the origin of the body fluid must be known. So that is why the hemasticks test is then performed, to see whether it is presumptive blood, but it is a presumptive test.
And your critique against the SOPs or the processes followed by Warrant Officer now with regards to the hemasticks is that she did not record the expiry dates of the hemasticks that she used. That was the first point of criticism.
That's correct, my Lord. That is indeed what I quoted.
Warrant Officer now testified that as far as she could remember at that point in time, the expiry dates for the hemasticks are recorded in a different logbook. It's not in her case file. If that were to be correct, would that satisfy your reading of the SOP?
My Lord, again, that is information that I do not have in front of me. I cannot verify it.
I just want to point out a mistake in what's being put to her. As far as I recall, she did say that, and then later she came back and said that there weren't any reports. I specifically remember that.
My Lord, as far as I remember, the witness came back and reported on something else, but I will leave it at that. It's not important. Dr. Olkers, then the second point of criticism against Warrant Officer Nell's procedure is the fact that she did not keep a record of the hemasticks.
Of the hemasticks result, that is correct, my Lord.
And you quote it on not mistaken, you quote page 223 of 413, paragraph 8 of the SAP bio 0043P. Is that correct? Record.
That is correct, my lord.
Now, if you have regard to the SOP as a whole, Dr. August, the SOP refers to the examiner shall make a drawing or have a photograph of the exhibit taken and indicate the location of the stain that tested positive. Now, do you not make a difference between an exhibit or a swab?
My lord, swabs are also submitted as exhibits. So,
There is a very, very big difference between an exhibit and a swab, Dr. August. An exhibit is an item that may or may not contain more than one stain and is found on a scene. So therefore it's collected, it's brought back to the laboratory, obviously for its possible evidential value, and then the submission officer or warrant officer, now I'm not sure what her title is, who sits with the exhibit, clearly marks, makes a drawing, and she testified, I make a drawing of the exhibit and I know where I made this cutting, where I made that cutting. A swab, to the contrary, is something that can only contain one sample. And although the sample may have been collected on the scene, the swab is brought by the officer in control of collecting the biological sample.
My lord, I would just, where does the information come from that this distinction? Nell did not, the warrant officer Nell did not testify, so he did not contest what was put to her in that regard. She should have made that note from the swab. In the documentation that we have of Nell herself, she's WW1, she refers consistently to the exhibits as swabs. Everyone.
Witness did testify, she keeps record.
Just adjust your question. Can't you?
And I just want to ask Dr. August, Lord, that what was Warrant Officer Nell with regards to hemosticks turning green or spotted? What was she supposed to keep record of in your view? Because she wrote down that it tested positive.
Okay, now you're addressing, put the question to the
No, I'm
Put the question to
putting the question to the witness, Lord, that Warrant Officer Nell did in fact keep a record of the hemosticks. She said it tested positive or it tested negative. What did you want her to keep more than that?
my lord, when a forensic laboratory performs a test, the records that should be kept should be in such a way that an independent analyst can verify them. Nobody can verify, so the hemosticks can have many different colors in the report, in the result, and the different results that were obtained. So were it blue, were it green, were it spotted, I have not seen data to that effect. So a simple photograph, for instance, would have sufficed so that one have a permanent record of the original result.
So you don't regard Warrant Officer now writing down the result that you got as positive or negative, you don't regard that as any form of record keeping?
My lord, it's record keeping, it's just not of the original result. It cannot be verified.
And even though Warrant Officer now also testified in re-examination that she said if she had to comment on which of the tests actually carry any weight, her presumptive test with the hemosticks or the actual DNA analysis, in her own words, the DNA analysis counts.
My lord, the DNA, I cannot stand in for the answer that Warrant Officer Nell gave. I can only say the processing of these, I'm going to call them exhibits, are sequential. So one step follows on the other. So presumptive testing is done, and then if it's positive, it goes through to isolation, as I understand it. The gravity of the original observation not being taken is clearly outlined, and I almost hesitate to mention ISO 17025 again, paragraph 4.13.2.1. On page 9, it says, the laboratory shall retain records of original observations, derived data, and sufficient information to establish an audit trail, calibration records, etc. And then that paragraph continues, my Lord. The last line is, the record shall include the identity of the personnel responsible, which we know the FSL did in this case, for the sampling, performance of each test and or calibration and checking of results. So it is the point that a record of the original observation was not kept and therefore cannot be verified, that I pointed out.
So it's the mere formula of the SOP that and ISO guidelines that you now objecting to that you don't follow.
My Lord, the ISO guide, as I've testified several times, exists to ensure scientifically valid results and should not be relied upon. They are scientifically invalid and wrong.
Dr. August, during cross-examination, it was put to Colonel Otto at some point in time that she is trying to get the answer that she wants. But even when she was confronted with a sample, one of your, I'm just not sure if it's AAA 11, 12, or 13, one of them, her testimony was exactly that, I know it is Martin van Breda's sample. I can see some of his alleles in that sample, but I do not read his profile in it because I do not see his complete profile in that sample. Do you recollect the evidence in that regard?
My Lord, I recollect that she was asked about that sample, and there was something about that sample that stood out to me when she gave that answer. Am I allowed to refer to that? Thank you, my Lord. And I just need to verify whether it was that sample and that my recollection is correct. My Lord, I am using just a summary of the profiles, which is the only document that I'm now just going to use. My Lord, what stood out to me about this sample, and I now recollect why the answer stuck in my mind, was that, and I want to state to the court that I'm doing exactly now as Lieutenant Otto interpreted from the electropherograms, and I'm not referring to the sample status report. Because I just wanted to point out one thing, and that was that when one looks at the profile of Martin van Breda, the full DNA profile, there are, except for 2 alleles, his profile could also have been read into it based, and I make the disclaimer again, my Lord, based only on the electropherogram. So when she testified, that stood out to me. And that was on page of the data bundle, page 469, there was a peak at the D8 locus that was not labelled, and I will talk about why it was not labelled in a moment, and also a peak at the position of allele 13 at the D5 locus. So had those two peaks actually been labelled by the system and been called, the profile of Martin van Breda could also have been read in. My thought at the time was that Colonel Otto did not speak about or address why the 13 and 12 was not labelled. She just said it was not labelled, so it didn't pass their quality checks, but I can't recall that she expanded on that. The rest of the profiles were there, so I take her by a word in her testimony that according to her, something happened to the quality of those two peaks, and that is why it was not labelled. I don't have information other than that.
So, even though she was only 2 alleles short, Colonel Otto was not prepared to call a sample that she read Martin's, could read Martin's profile in as Martin's profile because she was 2 alleles short. That is what I'm asking you.
My
Do you
Lord,
agree or not?
My Lord, correct, because there are 3 alleles on that profile that was not labelled and that was not called. One is the 13 and the 12 that was present in the profile of Martin van Breda, and one was the 22 foreign peak at the position of the 22 allele at FGA. My Lord, I cannot call it an allele, and so I have to correct myself all the time.
And Colonel Otto could also not call it or comment on it because, as you testified yourself, it did not pass her quality check.
My Lord, she had her own quality checks. I compared it to what was in her SOP, and I also referred to some other artifact information that is not in the SOP, and I also could not classify it as an artifact.
Are you saying, Dr. August, that Colonel Otto should have gone further than her own quality controls and checks and pull those peaks and alleles and read Martin's profile into that sample?
My Lord, that's not what I'm saying at all. I have already answered this question. I merely pointed out to the court the full comment that came into my mind. If I had to report on this sample, I would have reported it in totality. I would have said what profile could be read into it and that there were other peaks that remained unexplained.
See, Dr. August, that's why I'm putting this to you. It shows how objective Colonel Otto is. Even though she could have gone and, as you did,
If you put it to let's get the simple answer, but just
I will leave
don't
it at
pursue that too further. Much further.
My Lord, may I just answer
Yes, of
what
course, you may answer if you
she's
wish to.
already said?
I was trying to get you not to answer it, but if you wish to answer it, please answer it.
My Lord, I am here to assist the court, so I agree Colonel Otto could have pushed it and could have labelled it. She did not. But had she done that, she should have also mentioned the 22 allele. The issue that I take with the way that she reported it was that she did not report the full scientific
That point has been made.
picture to the court. Thank you, my Lord.
Dr. Ms. Galloway.
Thank you, Lord. Dr. August, now the court has already alluded to it, and you've mentioned yourself that you have something, a very long answer that you want to explain to the court why you say.
My Lord,
I have to ask you, sorry, just finish my question. In any of the information that you received from the laboratory, did you pick up any actual contamination? Not possible, or maybe, or it might have happened, actual contamination.
my Lord, there is one sample that I would like to bring to the attention of the court, It is a possible low-profile mixture as called by the FSL, by their own laboratory. Did I pick up contamination? If the samples follow on each other and there is a very low level that is carried over from one to the other, one would not pick it up.
Simple answer. Did you pick up actual contamination? Yes or no? I think either do.
My Lord, some of these samples were so little DNA was used that it was in the stochastic range where random effects happens.
I appreciate you made that point 75. It's a simple question. Did you pick up actual contamination?
And due to that reason, my Lord, I cannot just simply say yes or no. For the samples that we used...
So you're refusing to answer the question for a reason?
No, my Lord, I'm not refusing to.
That's not questions for,
Well, it's the answer.
on a scientific level, what the possible answers to that?
Yes, we can argue that. But the question actually to you is a very simple one. Did you pick up actual contamination? Or do you say that that answer is not capable of, that question is not capable of simple answer? Is that what you're saying?
My Lord, what I'm saying is there is an example where I wanted to prove to the court that it is possible that contamination could have happened there. But my Lord is asking not about possibilities, so not about probabilities. The court wants to know, did I definitively pick up contamination? The best answer I can give as a scientist is if there are several profiles of Rudy van der Walt following on a list, I cannot say because it is the same profile reported. I also did not get any information of where contamination occurred with the personnel working in the laboratory, which of course is not a concern here because that contamination is...
Which was the actual contamination?
So there are two types of contamination. Contamination that can happen within the laboratory by the people working in the laboratory, and that's what we are less concerned about here. What we are more concerned about here is whether there were contamination in the samples as they either were collected on the scene or as they were processed in the laboratory. So, my Lord, without the proviso...
That's good. Dr. August, during cross-examination of Colonel Otto, it was also, and please correct me if I'm wrong, I got the impression that it was inferred that the laboratory should have not just submitted more samples, but that more samples should have actually been analyzed properly. Is that your view, that in this case the laboratory should have done more?
My Lord, I missed the first part of the question. Whether... Thank you.
It was my impression. I'm not saying that that was what was meant by it. I'm trying to ascertain from you if my impression is correct or not. During cross-examination of Colonel Otto, I got the impression that it somehow hinted or implied that more samples ought to have been submitted for analysis or analyzed. Is that, do I have it correctly or do I not?
My Lord, somebody made a statement during, and it must have been during Colonel Otto's testimony because I was in court, where they say that a representative sample was taken. So if that sample is truly representative, then I can't see why more samples should have been taken. But if it's not representative, of course, then any forensic analyst would have taken more. So that is not how I understood the...
Then it's my fault. Thank you for clearing that up. Dr. August, then, if I understand the totality of your evidence correctly, you say that because the SOPs were not followed properly, it led to the result that the results obtained by the laboratory are scientifically invalid. That is a summary of the aspects that you pointed out to the court.
My Lord, there may be a few things that Colonel Otto and myself disagree on. On this, we do agree. She also testified that if a mistake happens, so an SOP is not followed, their system will pick it up, they will correct it, and then it will be reported. So I agree with that statement. However, it is clear to me in this case that all the non-conformances or all the mistakes were not picked up prior to report. And if I can just ask that the question be repeated again so that I can make sure I've answered every part of it.
My question is very simple, Dr. Corners. I'm actually giving you a summary of what your opinion is. I say, when one look at everything that you've spoken about these last number of days, in summary, it means that because the laboratory did not follow certain SOPs, certain procedures as prescribed, either in the SOPs or the ISO guidelines, it leads to the result that the results that they obtain are scientifically invalid.
Yes, my Lord. The reason I say that is it is the standard of the forensic laboratory that they deem to be appropriate to generate scientifically valid results. And it's also the ISO Guide 17025 standard that exists to make sure that labs know what standard to follow to generate scientifically valid results. So if the SOPs were not followed, if the ISO Guide was not followed, then yes, for those samples where that could be proven, those samples are scientifically invalid, wrong, and should not be relied upon for interpretation or conclusion.
Dr. August, the moment you realized that the laboratory, the FSL, had made mistakes or did not properly follow their own procedures or the ISO guides, why did you not request the extracts and do your own analysis of these samples? Because the most of them are still available.
Yes, my Lord, during Lieutenant Colonel Otto's testimony, I became aware that they are still available, but it is a valid question because it addresses scientific certainty. I will always argue in the favour of scientific certainty, which I had also put to counsel during consultation. What counsel did with that advice, my Lord, I cannot account for the reasoning.
Which reason?
That they did not request the samples to be retested.
The request to get the samples, was that part of your initial information that you requested when you asked for the paper on the SOPs?
No, my Lord, it was not part of the original request.
And if I read your report correctly, Dr. August, it seems to also imply that that was not part of your mandate to reanalyze the samples.
That was correct, my Lord. My Lord, I don't have to talk about the scope that narrowed again, I think.
If I might just have
My Lord, may I make a comment about something that came up yesterday that I was asked, and I think it's a mistake on my part, my Lord. I referred to Exhibit EE2, and I couldn't recall last night whether I said it's in the, something is in the SOP or in the OEM. I last night verified on EE2 under the sample preparation column in D, the yellow block where it says concentrate, that is in the OEM. So it's in the user's guide of the original equipment manufacturer, and it's not in the SOP, my Lord. And I'm just afraid that I couldn't recall last night what I said on the stand, whether it's in the SOP or the OEM, but so I would rather err to the side of being cautious and just point that out to the court today, that I could have made a mistake there. My Lord, then the court also asked me yesterday whether I was hampered in my analysis of the, I think it had to do with identifying the stutter, and when I spoke about the copies I got, they were black and white copies, and I had to use a ruler. The statement was made that I manipulated the data, which I categorically denied. Then I wanted to make clear that, did it hamper me? Yes. If we had received higher resolution printouts, that would have been better. If we had received electronic data, that would have even been better, or even printouts with the size, with the fragment sizes. So in the future, my lordship suggested already that I draw up a confidentiality agreement to use in the future, and so in the future I will make sure that that I point out to the FSL that they could have made a colour copy at the post office or something like that. And then I find it perplexing that we did not receive the information electronically, my lord, and I just wanted to point out that those were the instances where I felt that our analysis or audit were hampered and would have been much more efficient, quicker, so that because a lot of time was spent in that effort. So that's the only way in which I felt I was hampered, and also in the fact that we did not receive all of the SOPs. One concerns me probably the most, and that's the one about the paper trail, because I don't know what's in it. Yet we received, since my recollection is the 24th of August 2016, but I think the letter went from the instructing attorney's office only on the 6th of September last year, since we requested the entire paper trail. So my lord asked me to come back on that. And my lord, also the state asked me to go and look at a sample that was handed in, and if I may address that also. My lord, the state asked me to go and look at a sample, AAA1, and I faced in this trial an email of 14 years ago which I didn't answer, so I don't want there to be in the future being referred back to this case because I didn't point this out. So I was asked to look at AAA1, AX 6A, and the state's question was, is the sample valid? So my answer, and I had to look through it, and I realized that Warrant Officer Nell did not do the hemistic. So I don't recollect, my lord, but I believe Captain Hubert did the hemistics of that particular sample. I stand to be corrected. But I think Lieutenant Colonel Otto testified that it was done in the evidence recovery laboratory of the FSL. Then on the second, so the aspects that I addressed in my report, that was the one thing. The other thing was the level of, or the amount of DNA that was used. That was appropriate. It was 1.699 nanograms, so it was...
Your re-examination, Mr.
I beg your pardon, my lord.
It's legal, sir.
Oh, my lord, I'm just trying to satisfy the state for the question that she asked. And then also the samples following on the same work list. And in this case, the sample was in lane 13, and I have no information on lanes 14 and 12. Then about the analyst proficiency, the same CTS proficiency test that Lieutenant Colonel Otto performed was also performed for, and I apologize that I do not know the title, but the Visagi member of the FSL who performed qPCR. My lord, that is, as far as I know, there was also a question whether the SOPs are aligned to 17025, which I did address this morning, I believe, my lord. I addressed the issue of the uncertainty of measurement, the fact that the quality system does not pick up the non-conformances, and that the SOPs have not been followed, and that Colonel Otto may not necessarily know that at the end. ISO guide makes it clear that such a system must be effective, so that it pick up, my lord, and that I think, to the best of my knowledge, those were the issues that I had to.
I have something more to put the witness, Lord. In all fairness, I would like to put the witness, Dr. office what regarding case law, regarding the manner in which an expert witness should testify, feel that maybe you would want an opportunity to comment on what I'm going to argue to the court at the end of the day. I'm not going to quote the judgments to you, but case law says that firstly, after an exchange of reports, if after exchange of reports an expert changes his view on a material matter, having read the other side's expert's report, or for any other reason, such change of view should be communicated to the other side without delay and when appropriate to the court. The fact of the matter is, Dr. Walters, it is inferred in this paragraph that there should be an exchange of reports. You testified about your initial report having been made available for counsel's attention only. You are the expert witness here. Did you impress on counsel that the state needed to have access to that report?
And what I suspect, I don't think that is a new position. I've never, in criminal law, I've never heard of exchange reports thus far.
My Lord, if I may say from
The witness wants to answer. The witness answer.
From-
You don't take the matter further either way.
from my perspective, I have been acting in this role for 18 years, and I've never been asked to write a report. So that may have then been the mission of all of the previous councils. I have no reason to know why they didn't request a report.
Okay, next question.
There is also a judgment commenting on when an expert witness's objectivity and the credibility of his opinions may be called into question, and it is listed as firstly accepts to perform his or her mandate in a restricted manner. You accepted the mandate, but only ordered the process.
My Lord, when we consulted with the council in the beginning, I said there are several ways of getting to scientific certainty. I explained in great detail that all the texts.
This is now getting privileged information.
Yes, that the point is well taken. It's going to be, I don't think we can go into what they discuss with
I will
council.
leave
Privilege applies, no?
There is just then two aspects that I need to point out to the witness: criticisms made against her in previous judgments, which I've already
That you can
referred
put
to.
through.
Sorry. I again refer the witness to the judgment of Mrs. Justice Ali in the Rafafari matter. On page 8 of the judgment, the court says the information obtained, conclusions reached, and results of the DNA test performed by Colonel Otto in this case could, however, not be seriously challenged given the paucity of Dr. August's practical experience in forensic science laboratories and the lack of statistical knowledge. You still have no practical experience in the laboratory, Dr. August. Would you like to comment on the findings of the court?
My Lord, not having the judgment in front of me, I want to address the aspect of my lack of statistical knowledge. Is that how it's put? I did testify in that case, as I did here, that I'm not a statistician. But of course, the statistics that we use in forensics, calculating the random match probabilities, for instance, I'm very well aware of that, and in fact train other forensic scientists how to do it. The SOPs we have covered. I conveyed it to Mr. Guess was the instructing attorney. I found that email in his report requesting the data. It was not there. As I recall, I became late involved in that case. So that is the case. My Lord, can I just ask that the rest of the section be read so that I just make sure I address it all?
The first that you left out of the office is the paucity of the practical experience, and that was the actual reason for quoting that to you, is that you still have very little, if any, practical experience in the forensic laboratory.
My Lord, I have already testified. I've never worked in a forensic science laboratory. I have, however, spent, now I'm going to give my age away. I graduated let's say around the 1990s, early, my Lord, in 89. 89, it's in my CV. So, my Lord, I graduated then. Thank you, my Lord. It's not that I'm uncomfortable or anything, it's just I do need a break from the sitting from time to time. So I have worked my entire life in a molecular biology laboratory, my entire life. I have run forensic courses my entire life. I have, well, not my entire life, molecular biology courses, since I was at the University of Pretoria. My Lord, I was, yes, but the, thank you, my Lord. The state made several references to my only academic experience, my mainly academic and administrative experience, and I contest that to this in the strongest possible terms, my Lord. I have, when I look at example EEE, as Colonel Otto, perhaps I should start there, as Colonel Otto testified, she no longer is proficient in all of the tests involved in DNA analysis. She has risen in her own laboratory to become the person that interprets, that writes the report. So that's similar to my role as a CEO, even though I'm still practically involved in presenting courses and so. But in sample, in DNA isolation, my Lord, I have decades of experience of extracting DNA samples. The only number I have in my mind is that during only the study for my PhD, I produced 13,000 plus STRs. So I screened the human genome. So I have ample experience in DNA isolation, how to prevent contamination. I've taught more than 30 masters and PhD students how to do that. Yes, my Lord, but the state is putting it in front of the court again and making it sound as though I merely have academic experience. My academic experience was in a molecular biology laboratory, training molecular biology students in human genetics, in STR analysis, in
Point is, did you work in the forensic science department?
My Lord, that I've already answered, no.
That's a simple point.
In the judgment of S versus M. Ori and another, it is an unreported judgment on the merits of the matter given by Mr. Justice Bozalet in case number SS 32 of 2003 on the 14th of October 2004. After having considered, you, in actual fact, firstly, you didn't testify in this matter, if I'm correct.
That's correct, my Lord, because I'm not always contracted to testify.
Ori, state this is Ori, my Lord?
Oh, the Ori case.
The Ori case.
Oh, no.
We will provide a full copy to the, I've made notes on my part that I have. Sorry, you were, however, present in the court when Superintendent Phillips and Henoch were cross-examined by the defense.
That is my recollection also, my Lord.
And you did similar as you did in this matter. You requested a voluminous file of information from the laboratory relating to the entire process of receiving, registering, and holding the samples, the process of subjecting them to DNA testing and analysis, as well as ancillary documentation. Is that correct?
My Lord, I can't recall the exact wording, but it sounds correct because we usually now, as I said, since 1998, in the Parker case, we request the entire paper trail or all results.
And in fact, all of the witnesses in the laboratory related to what in legal terms is called the chain of evidence, all of those witnesses had to be called by the state. Do you recollect that?
My Lord, I cannot recollect it for the Ori case. I do recollect it for the case in Bloemfontein last year, that was State versus Ramutibe, and it had something to do with the reporting officer only giving hearsay evidence. I don't understand the legal ramification of that, but I do know in the Ramutibe case, my lord, I think more than 20 people pitched up in court, and not all of them even had to be there, and we couldn't.
But you challenged the chain, so they have to be there to establish the chain. Is that not the situation?
My lord, how the law operates in that regard, Advocate Nkantle will be able to say exactly what his strategy was in that.
Okay, I can assist you with the Ori matter, Dr. Walters. The judge, in his judgment, found that on page 12, by my reckoning, in order to prove this chain of evidence, the state called no less than 16 witnesses, of whom 11 testified regarding the various processes of DNA testing of the samples. Of these 11, the principal witnesses were Superintendent Phillips, a control forensic analyst who completed the final analysis of the blood sample, and Senior Superintendent Hennock, the head of the biology unit at the forensic laboratory. The court goes further on page 13, line 9. Every witness in the chain of technicians was cross-examined, with further cross-examination being reserved, dependent upon instructions which might eventually be received from the defence's DNA expert. None of the technicians were ever recalled for further cross-examination. At the end of this entire process, which must have taken no less than 4 days, the sum total of the defence's challenge to the DNA evidence amounted to the proposition that the laboratory's culture was such that no reliance could be placed on any results by the laboratory.
My lord, am I understanding correctly? And I want to make clear that I understand, or I want to make sure that I understand. Is the state asking me to speak to how the court interpreted the evidence that was put to it in front of the court by the council? Because I didn't put...
The simple point is this, if I understand, to perhaps I'm wrong. You see that in all these cases, the minute you feature as part of the dramatis personae, then there's a great deal of discovery that the state has to do. And very often it has to be a lot of evidence to prove the chain involving acquiring these samples. That's basically the work you do. You challenge you first find out everything possible that could be found out about the testing done, and then dispute the chain of evidence. It seems to be your function as a scientist, of course.
My lord, I see my role as assisting the court in verifying the scientific validity.
Yes, no, but the consequence of that. It's not criticizing you, but a simple statement of fact that your appearance in the matter leads to these consequences.
My lord, I would argue that the appearance of any independent expert would lead to probably the same as I have in this field, as I have seen in or heard from other experts in this field.
And if I may just quickly list to you the criticisms you raised in Ori against the processes of the laboratory ascertained to, similar as in this one, the batch the lanes that follow each other, the same samples, the proficiency of an analyst, which wasn't further taken up with the actual analyst when he testified, that there would appear to be writing errors on the paper trail, and the accreditation or non-accredited status of the laboratory. It's a summary of the criticism you had against the laboratory in the Ori matter.
My lord, in every case, we would request the paper trail. I yesterday verified that it was not done in the SOPs were not requested, as far as I could tell, in the Rabhadi matter. I did request in the Ori matter the SOPs, discuss it with Mr. Khan. I just couldn't find whether that was also then part of the discovery. So every time we do this, one would take ISO 17025 or any standard that the laboratories say they follow. So it is actually then, to me as a scientist, quite alarming that these issues persist, because they should have now been cleared out. That is according to 17025. It says a system must be in place to pick up these errors so that they do not recur in the laboratory, but that the same type of errors are picked up, yes, because 17025 and the SOPs should be aligned, and 17025 has not changed since 2005, and I don't know what year the ORI matter was, but the gist of the ISO guides don't change. They are there to verify that the samples that are submitted to court remain valid, and it seems as though the ORI matter was in 2004, my lord.
The judge's comment and finding on the similar criticisms that you raised in the ORI matter, Dr. August, I'm reading from page 16 of the judgment, as from line 3. The criticisms levelled by Professor Alkers in the Mukina case were substantial, whereas in the present case they are limited and formalistic, relating in many instances to inadequate record keeping, and as much do not, in my view, touch on the accuracy or the reliability of the substantive tests and the results thereof. He goes further in page, the same page, line 17. The state's expert considered these few instances of non-compliance. Referred to that duplicates was done in the same batch. The original and duplicate were not in all instances kept sufficiently far apart in the batch. The state's expert considered these few instances of non-compliance, but expressed the firm view that such deviations in no way affected the accuracy of the results or the integrity of the testing process. I have heard no evidence to suggest the contrary. The court also commented that the conclusion that they wanted to have drawn, as you testified, to say that it would apply to each and every DNA result produced by the laboratory in the past or in the future whilst it operates under the same conditions. Needless to say, this is an extraordinarily far-reaching conclusion, and one which I have no hesitation in declining to accept based on the evidence before me. And the court went on and he accepted the DNA evidence presented by the state. And in this instance, an accused was linked to a crime scene by way of, if my memory serves me, a single blood spot on the curtains of the house.
My lord, if I understand the state correctly, after all of that, which I don't have in front of me, which I accept at face value, that how the judge, what the court takes into account when making a judgment, I cannot speak to that. I can simply not speak to that. That the same batches or that lanes follow on the samples follow each other on a lane seems to have been the same issue. The proficiency tests, the writing errors, they were, my lord, one of the aspects I do recall, it was I will say in a professional manner, an interesting part in the case when it was pointed out that other than in this state van Breda case that we are dealing with, a lot of the forms that had to be signed by analysts were not signed, and it was not signed by the witness. And when we pointed out 60 of those, the judge said those were mere administrative errors. So in the scientific world, that for us means that there's a break in the chain of evidence. So I cannot speak to...
Judges that Ms. Gilder has spoken to were unhappy with you.
My lord, yes, I note that...
I've never read the judgment.
I-
Okay. But the other one she did, the one she did, yeah.
in the...
With all due respect, she did testify in the Rapahari matter in the regional court.
That is correct. And I did not, my lord, I did not testify in the ORI matter. My lord, no.
But whether one or two judges, somebody was unhappy with it.
My lord,
That's as far as
and
Ms.
I'm-
Gilder can take it, not much further either.
My Lord, and I cannot speak to my Lord, I need one moment to think about whether I'm allowed to speak about something or not. At the legal level.
Maybe if the witness wants time to think and see it's 11:10, maybe if we just...
My,
You can think about it. You have to.
my Lord,